The docket is C19-0311-482 in re DW. Good morning, Ms. Kars-Nestler.
Good morning.
And is it Mr. Haviland? Are you representing the state this morning on this?
Not on this one.
Or is it Ms. Adams?
Correct.
Okay, I'm sorry. You're not all on my screen. I have too many bars. I can't. So I thought it was Ms. Adams. All right. And the parties are ready to argue this morning?
Yes, Your Honor.
All right, thank you. Ms. Kars-Nestler, did you wish to reserve some time in rebuttal?
Yes, Your Honor. 5 minutes, please.
All right. And again, I'll kind of keep your time. If you're getting close, I'll kind of let you know. So when you're ready.
Okay. May it please the court, I'm Julie Kars-Nestler, and I represent the appellant DW in this matter. 14-year-old boys engage in inappropriate and sometimes annoying behavior. The issue in this case is a simple one, and it's whether the evidence was sufficient to establish the offense of sexual imposition as a matter of law. DW contends that the grabbing of Ms. Dillman's buttocks alone was insufficient to establish the offense. And for this reason, we are asking this court to reverse the adjudication.
But Ms. Nestler, you have to admit, you cited that case, the Redmond case, and I read that. And that was in a high school, in a hallway, very different from the facts we have in this case. The victim was alone in a parking garage. He targeted her out. He followed her. It was a two-hand hard squeeze in the erogenous zone. How is that? You cited the Redmond case. Isn't that very starkly different from the facts we have here?
Your Honor, I submit to this court that really the very salient fact in the Redmond case was the fact that it was a teenage boy. So I think from the outset, this court that is a distinguishing factor for this court that has to really it's the lens that this court must review the facts in. And they did find that to be compelling in their analysis in the Redmond case. And similarly, it should be compelling in this case. We would submit that I don't believe the evidence, the record indicates that DW followed Ms. Dillman. There was video evidence provided. There was the actual incident was not on video, but him entering the parking lot, the parking garage was. Again, and also an important factor, and I believe the Redmond case that was cited was this was a public.
I think your point on that video is that the victim enters through the glass doors, which is adjacent to the escalator, goes up the escalator. There's another gentleman that comes, he goes up the escalator, and then you see the defendant coming down a hallway and he goes up the escalator, at which point at least at that point, he wouldn't have visual contact with the victim.
That's correct, Your Honor.
At entry.
That's correct. That's correct. The point that I was attempting to make was I don't believe the record shows, for instance, that DW was following her prior to that point. It wasn't as though he watched her leave from the office, for instance, and followed him to the parking garage. I think that she went in well before him. And again, I would point that this was a public place, although she might have not been with a companion or a friend at that point. This was a public area. There was cameras that were involved. The nature of the contact, as Judge Mock pointed out, this was a firm grab of the erogenous zone. Again, the contact is insufficient to establish the offense. There has to be some sort of fact or circumstances that gives rise to the inference that this was for sexual motivation. Again, DW said nothing before or after the contact. He just simply walked away. It wasn't until Ms. Dillman started chasing him that he ran. So,
and Attorney Nestler, do we know what the time proximity was from the incident until she goes to the booth to talk to the booth person?
I believe Your Honor, the record indicates that it was quite immediate. I do know that she testified that she ran after DW, but was unable to catch up to him. And that after that point, she then went directly to the booth and reported the incident.
And what time of the day was this?
The Miss Dillman testified that it was, I believe, approximately 5 p.m. That this occurred. It was right
So,
after her
okay.
birthday.
So it was the end of the business day, and this was the work garage.
Yes, Your Honor, that's correct.
Okay. Thank you.
Sure. So again, and when this court reviews the juvenile court's decision, it's clear that when they made the assessment of the facts, they were focused on the subjective intent and how this contact made the victim feel. I believe in the decision, he says that it, quote, made her feel disgusting. Well, that might be a relevant issue related to other facts or elements of the offense. It is not dispositive as to DW's specific intent in this case. And that's what this offense
But
is.
Ms. Nessler, the court's to consider the type, nature, and the circumstances of the contact. So wouldn't that fall, the victim's testimony about that it felt disgusting, wouldn't that fall underneath the circumstances of contact for the court to determine the intent and the purpose?
Your Honor, I believe that it would fall under the other element of the offense is that the defendant has to know that the contact would be offensive to the person or reckless in that regard. So while it's certainly a relevant fact for another element for this offense, the subjective victim's how she felt is not dispositive. Again, the question before the court and the question before this court is what was DW's specific intent, because that's what this crime is. It's a specific intent crime. The contact alone is not enough. If it was, this would be a strict liability offense, and it just isn't. We just contend to this court that the evidence giving rise to the inference that this was sexually motivated is lacking, and that's why we'd be asking for this court to reverse.
But weren't there other factors that the trial judge considered in making his determination? Besides the contact of the erogenous zone?
The facts that the juvenile court cited to, that it was a grab from behind, that it was forceful, that he fled after being chased. Those are the additional factors, Your Honor, that I believe that you're referring to. And none of those from the defense position give rise to that inference that this was sexually motivated. It is potentially that it was disorderly or potentially assaultive, but not sexually motivated. And that was the issue before the court. So it's for that reason that even the evidence and the circumstances that the juvenile court cited to are insufficient to establish this offense. So for those reasons, if there's no additional questions, we would ask that this court reverse DW's adjudication.
Thank you, counsel. Ms. Adams?
Yes. Good morning, Your Honors. Ms. Nessler. I believe Judge Mock already touched upon what's relevant here is the type, nature, and circumstances of the contact. Certainly, if we were to isolate, as Ms. Nessler is asking the court to do, just the instance of the grabbing of the buttocks. Certainly, there may be a stronger argument there, but that's not what we have here. We have, this woman was targeted. And as Ms. Nessler pointed out, there was a gentleman early on in the video that we see, but it was this female who was at this point kind of isolated from anyone else who was targeted. She was distracted. She was on her phone. And the contact was forceful, and it was with the buttocks. It wasn't her arm. It wasn't as if you were trying to grab the cell phone from her. So all of those facts and circumstances were certainly, it was incumbent upon the magistrate to take all of that into consideration. And in this case, there was sufficient evidence to make that inference of what his purpose was. And I think—
What would distinguish this case from an assault case?
Well, I believe it is the erogenous zone. Again, if we were to look at the circumstances, the getting off the escalator, there were certainly other parts of her body that could have been grabbed. But
the legislature, when they created this law, they determined that it was that just touching the erogenous zone is not sufficient. Isn't that correct?
Well, this And that's not what we have though. And that's why I said at the beginning, if we were to isolate that moment and that's all we looked at, but again, we have very obviously this woman was targeted. She was distracted.
And
It was
what in
clear
the
she was
facts make it
alone.
obvious that she was targeted?
Well, I think when the video that Your Honor talked about, there was an individual, and I may be getting it mixed up with the other video, but I think we even see a little bit of DW over off to the side, where it was certainly that gentleman went up the escalator, but it wasn't until after the victim in this case got on the escalator that then he entered the escalator. So I do believe that is some indication of she was targeted.
So
Again,
is it your position that, because the victim comes from a different area, he's coming down a corridor, and she's coming in through a doorway with, there's no, I mean, was there any evidence that there was a visibility line from that corridor to the victim?
not that's in the record, Your Honor. Again, this is Procter and Gamble's employee parking garage. So this individual, I mean, DW had no purpose, to be in that parking garage. So as the victim comes in the doors, that's kind of when the video picks up. So again, we can't isolate that moment of the contact. It's all of the circumstances surrounding that.
And I agree with that. And that's exactly what the legislature intended. I would like to really understand more of your perspective as to what are those circumstances and how would they distinguish them from an assault that would be on an erogenous zone. Because the legislature requires more than the contact with the erogenous zone.
Right. And again, looking at, and if you talk about the victim's feel, she described the contact. It was forceful. It was with both hands, and it made her feel disgusting. I don't think that we can completely ignore what the victim's feeling, what her gut reaction, what her feeling is to that contact. For her, the one who received the contact. I don't think that this court is required, or the trial court was required to ignore how it made her feel. That's certainly strong indication.
That's certainly a factor that should be considered, and the case law directs us to do such. But how would that feeling be any different from an assault in an erogenous zone?
Well,
because it requires, for the purposes of sexual gratification.
Correct. And again, that's why the case law has provided that inference for the court to make. And I don't know that an inference is something that is talked about when we're, an assault. An assault is just clearly the contact. Here, again, he could have touched her anywhere else. Her entire back part of her body is at his disposal at that moment, but it was targeting that. And again, the circumstances, and then we look at after the fact.
So are you saying that targeting that area can only be for sexual gratification?
Well, I think if we were to only look at that isolated, but we can't. Again, she's distracted. No one else is around, and the way the victim felt, I think that is a very strong indication here. And his behavior afterwards, and if this were just some brushing upon as they passed or something, certainly his flight afterwards, and the court can see that, running down the up escalator, certainly that is part of the circumstance in this case that the trier of fact was obligated to consider as well. I have nothing further unless there's any other questions.
Any questions? All right. Thank you, counsel.
Thank you.
Ms. Nestler.
Thank you, Your Honor. Just a few things. I think the case law is clear that you cannot build upon inferences. Evidence, it cannot be an inference upon an inference to establish an element. And I think essentially that's what the state of Ohio is asking this court to do. In all of the facts that the court or that the state cited to the court this morning, the fact that it was forceful, the fact that the grab was with both hands, the fact that the victim was distracted, all of these are suggestive of more assaultive or disorderly behavior. Again, none of those give rise that this was for sexual motivation. And the DW did not flee immediately. He made the contact and walked away. It was not until Ms. Dillman started chasing him that he started running, which seemingly would be an appropriate response. And DW was charged and adjudicated with the criminal trespass of this garage. He's not obviously challenging that adjudication, but he was adjudicated of that. Again,
well, Ms. Eshel, just let me ask you then on that point about there's nothing in the transcript that I read that DW said anything at all.
That's correct.
During that. Well, isn't that a fact in itself that the court considered? I mean, if it was supposed to be something playful, he could have said, I'm playing around, something else. But the fact that he said nothing, isn't that another factor that the trial judge could consider?
I think they could, Your Honor, but I don't see how this provides any sort of inference of a sexual motivation. The cases where a lot of the cases that that they looked at the comments by the defendant before or afterwards to be suggestive of kind of a direct intent. For example, this court's decision in N. Ray Mack, I believe the defendant had touched the buttocks of a younger female and then was asking her how babies made. This court utilized the defendant's statement to say that obviously this is suggestive that his motivation in touching her erogenous zones was certainly sexually motivated. And so for the defense, the absence of that, of any sort of comment like that on the part of DW, it's clear that there was no direct evidence of intent. The absence of a statement, I don't think gives rise to any sort of inference in this case. And again, we would.
And attorney, that's like, I think we all agreed that obviously this woman was groped by the defendant. So the question is whether it was for the purposes of sexual gratification or and there's many other purposes, when people get groped, it's not always sexual gratification. Sometimes it's an exertion of control, of power, different things. So the question is, how would you distinguish it between being groped for sexual gratification versus for another purpose?
Well, Your Honor, I think you make a very good point, is that it could be for a bunch of different purposes. And that's why the Redmond court, they specifically said that we can come up with a number of reasons why this classmate lifted the skirt of the female classmate. But the salient issue is, did the state of Ohio prove beyond a reasonable doubt that DW's purpose in making this contact was for sexual gratification? And the record is just lacking as to that point. So that is why we'd be asking this court to reverse the adjudication. And again, this court must look at the facts in the lens of the fact that this was a young boy. It was a 14-year-old boy who engaged in this conduct. So for all of these reasons, we would be asking this court to reverse the juvenile court's decision and reverse DW's adjudication.
Thank you, counsel.
Thank
All right, thank you for your arguments. The case is now submitted. Thank you. All right, next matter on the docket this morning is case number C19-0697. It's Robert G. O'Brien and Cheryl O'Brien versus the Great Parks of Hamilton County and Humana, John and Jane Does 1 through 5. Morning, counsel. So for we have a lot of lawyers on. Who's arguing on behalf of the appellates and who's arguing on behalf of the appellee this morning?
Amanda Patton's going to argue the first portion for us on the appellants, and I was going to do the rebuttal portion.
All right.
I think we wanted 10 minutes for the first part, 5 minutes for the second.
All right. That makes it easy. And then for the appellees, it's
Good morning, Your Honor. Kurt Irie on behalf of Creative Parks.
All right, then, Ms. Patton, you have your 10 minutes when you're ready.
May it please the court and good morning. This case involves the statutory immunity issues. There are, the facts in this case are pretty simple. One of the employees was driving a Sidewinder lawnmower at the golf course. The lawnmower was stopped at the top of the hill. Mr. O'Brien was on one of the putting areas, and the lawnmower came down the hill and hit Mr. O'Brien. He got thrown up on top of the lawnmower and then fell off of it and was injured. And there's really only two explanations for how that happened. Either the brakes weren't working on the lawnmower, or the employee who was riding on the lawnmower didn't pull the brakes. And that's really the only two possible ways that a lawnmower hits a person. So we're not arguing that the golf course wasn't a governmental function. What we're arguing is that there is an exception. Immunity is not unlimited, and that the RK versus Little Miami Golf Center case pointed out that immunity is not intended to protect conduct which requires very little discretion or independent judgment. And making sure that the brakes work and making sure that you pull the brakes so you don't hit someone on the golf course isn't a discretionary decision. And then the statute requires the defect to be either within or on the grounds. The trial court agreed that the golf center building is considered a building within or on the grounds. And so the question becomes, was the lawnmower within or on the grounds? Well, it was on the golf court, and so I don't think that's an issue either. And then as far as the employee negligence goes, there's only two ways that this happened. Either the employee did not hit the brake or the brakes did not work. And no matter which way you look at it, you can't just hit someone with a lawnmower, you can't hit someone with your vehicle. And that's really the focus of this case.
Well, Ms. Patton, was the motor vehicle exception even raised below? And how so?
It wasn't in the pleadings, but it was raised orally when they had the off the record argument on the hearing.
So it was off the record, so we don't have the ability to review that. Is that correct?
That's correct, yes.
Thank you.
Ms. Patton, did anyone, any experts take a look at that lawnmower from a plaintiff's perspective and determine whether or not there was defective brakes?
From what I understand, no one was able to take a look at it except for Mr. Bruce, who was the investigating person, and his results revealed that it was inconclusive. But the report that he did take into account when he investigated came from the park rangers, where the only time that the person who was driving or on the lawnmower was available said that he was pulling the brakes. And Mr. O'Brien said that he believed that he was trying to hit the brakes and they just weren't working. But because the driver or the person on the lawnmower wasn't available, that's as far as we have on that end.
Okay, thank you.
Ms. Patton, was this one of these lawnmowers that they ride behind sort of on a little platform, or was this actually like on a tractor? I wasn't clear on what type of actual lawnmower this was.
I believe it was the one where they ride on, the Sidewinder. That sits up pretty high. It's one of the industrial lawnmowers. It's not like a push lawnmower, one of the ones that you ride around your yard.
Thank you.
So ultimately, your argument is under the B4 section. Is that correct?
Yeah, I think that's the strongest argument on this case.
Okay. So what would you say is the tribal issue of fact under the B4? Or more importantly, actually, before we even get there, how did you establish the B4 section?
Well, because it's employee negligence that occurs within or on the grounds of a building used in connection with a governmental function. And so the trial court agreed that that was a governmental building. And the first district had ruled that in the RK Little Miami Golf Center case, that the golf course building could qualify as a building with a governmental function. So that's the first part. And then employee negligence is the employee was actually on this lawnmower. It wasn't just a lawnmower that was sitting at the top of the hill. There was actually someone on this lawnmower at the time. And then as far as the physical defect.
But what was the evidence of the employee negligence? Because that was one of the elements that the trial court felt was not established.
The evidence would be that the employee was actually sitting on the lawnmower itself. There's not really a dispute that it wasn't on at that point in time. So it wasn't, he was operating it and it just lost control. He was sitting at the top of the hill. And at some point that lawnmower came down the hill and hit our client. And so lawnmowers don't just hit people. And so either there's faulty brakes or he didn't hit the brake. And that really is what boils down to the negligence part. I mean, it's a distinction without a difference really as far as how it happened, because there's only really two explanations, and you can't hit someone with your vehicle and there not be some level of negligence there. And then as far as the physical defect goes, either there's defective brakes or defective operation of the lawnmower. And so that's really the crux of that exception.
And what was the evidence? Because that was the other element that the trial court also felt that the evidence wasn't there.
The evidence would be that the lawnmower came down the hill. Lawnmowers that are stationary don't just all of a sudden run down and hit someone. And so that would be the evidence in and of itself. And it would almost borderline on the res ipsa issue of, lawnmowers don't just hit people. And so that, as far as that goes, that's pretty explanatory of what's happening here is, you have a stationary lawnmower that hits somebody. And I don't know that you can get much more issue than that.
Ma'am, was there any evidence that the employee knew that the brakes weren't working? Or
the only thing that was really that came out was in a park ranger report, which I know there's a dispute as to whether that's here or there, but it was taken into account in their investigator Dave Bruce's review of the case. And in that situation, the employee did actually say that he was trying to pull the brakes and the brakes weren't working.
okay.
And then just on the, so if the exception applies and then you have the third level, the third tier of immunity, I just wanted to hit on that really quick, is that I don't think our opinion is that this is not a discretionary decision. Which lawnmower to use, where to use the lawnmower is absolutely discretionary. But whether or not you're operating it not to hit somebody is not discretionary. And even if it was discretionary, then you get onto that reckless and wanton manner, which if you hit someone with a lawnmower, you're not exercising a duty of care towards those people, because you do have a great probability of harm when you're operating these large lawnmowers that he was operating at the time.
I'm sorry, Ms. Pat. I was going to say, if there are any other questions from the panel, you can, if you're not finished, you can reserve the rest of your time in rebuttal.
We'd like to reserve the rest of the time if there's no further questions.
Thank you. Mr. Irie.
Yes, thank you, Your Honors. Good morning. On behalf of Great Parts of Hamilton County, obviously our defense in this case involves the immunity defense, and the argument turns on the exception of 274402B4 as to whether or not the three elements for that exception were met. I think it's important to point out that plaintiffs seem to conflate the two separate elements that they must show on the exception, one being employee negligence and the other being a physical defect. And we argue, and as the trial court found, there's not proof in the record of either in this instance. Therefore, there's no exception to immunity, and the general grant of immunity, which is undisputed in this case, remains, and the Park District is therefore immune from any liability. The employee negligence facet of this defense, there's no evidence in the record that the employee did anything or knew of any condition with the tractor that would have caused this injury. There was a allegation of involving an incident report as to whether or not certain things were said or reported to a park ranger. That was never made part of the record, and as the trial court correctly found, there's no evidence in the record to show employee negligence. In regards to the physical defect, similar thing. They keep claiming in their brief that there was a faulty brakes. There was no attempt to inspect the mower. There was no attempt to question the mechanic who repaired the mower and kept it in good working order. And in fact,
Mr. Ivory, wasn't the mower damaged though in the accident? Wasn't so? Wouldn't have been. It might not have shown anything anyways.
That's true. That's true, Your Honor. The Dave Bruce, who's the risk manager, did a investigation of it, and it was inconclusive as to whether there was the damage occurred during the accident or when it existed. All we know from the report, from the affidavit that the mechanic put on, was that it was in good working order and there was no mechanical issues outside of normal wear and tear. And then when it was evaluated afterwards by a third party, there was some damage that was seen on the mower, but it's unclear when that damage occurred. It very well could have occurred in the accident itself. Therefore, we argue that if it didn't pre-exist the accident, there's no way there could have been a quote unquote physical defect with the mower, even if that damage, which is unknown exactly what the damage was, if that had any relationship to this injury. And that's what the exception requires, that there be a physical defect that caused the injury, and you just don't have that in this case. And I guess plaintiffs are no longer touching on the motor vehicle exception, and I will leave that to our briefing with the court. I don't think it was raised at the trial level, and I don't think that this court can consider it. So we're stuck with the physical defect exception, and as I said, we don't believe that either the employee negligence or the physical defect requirements are met. There's just not evidence in the record to support either of them.
What is your position on the second prong of the B4, which is on the grounds of the buildings used in connection?
Yeah, and that's a more interesting argument, Your Honor. Obviously, I think the trial court found that based on another case involving Great Parks, that because there was a clubhouse, that this qualified as grounds. We argue that
and in that case, wasn't it a tree limb? Wasn't there a tree limb involved?
There was, Your Honor. That's correct. There was a tree limb on a golf course, and they said that the tree limb is obviously a tree was growing on a golf course, and the golf course had a clubhouse on it, and they've said therefore there's a building on the grounds of the property owned by the Park District. This, we argue, is different, Your Honor. It's unlike other cases and where this issue has come up because this involved a lawnmower, a transitory object that was not stationary on the grounds. It's our argument that it's different. It's a unique situation, and therefore not even that prong does not apply because you don't have a physical defect existing on the grounds because you have an object that merely traverses the grounds. That whether or not it's on the grounds may depend on the day or the time of day as to where the vehicle is. So we don't believe it applies either.
Well, because it seems to me that if it did apply, then pretty much anything that's on the grounds, not on the grounds, but on the grounds, that is connected with or the property of the entity, of the business of the entity, then would then fit into this.
Yeah, and I think that's where the courts have made it, at least the case law that we rely on, the distinction has been that almost every physical defect where it's been considered by Ohio courts has been some object that's been affixed to the grounds. So I think the General Assembly made this exception of a physical defect. So you have a premises liability situation and you have actual an object that is affixed to the ground that is part of the premises that can be discovered. Whereas here we have a transitory object that's moving, that may be on the grounds, may not be on the grounds, depending upon the time of day. We believe that's the distinction, Your Honor. So just to reiterate, that the exception is quite clear. The General Assembly amended this exception, the physical defect exception, to include the language of there being a physical defect in 2003. But prior to that, it was just employee negligence. So it's clear that the General Assembly intended that all three prongs must be met. There must be proof of a physical defect. There must be proof of employee negligence. There must be proof that the physical defect and employee negligence occurred on grounds or building owned by the political subdivision. Here we say none of them are met. You don't have record evidence of employee negligence. You don't have record evidence of a physical defect. In fact, you have the opposite here. You have evidence that this mower was in good working condition, damage that may have occurred in the incident itself, but there's no proof that what this damage was or that this damage is in any way linked to this accident. Therefore, we believe that the immunity exception does not apply. And
I think, you know, as I think about the appellant's argument, I'm going to kind of, I think what they're basically arguing is if a lawnmower takes off, if it's at the top of the hill and it just takes off, there can, you know, that's indicative of that in and of itself is indicative of either a defect with the lawnmower or that the employee had done something or failed to do something that they should have done or should not have done. I think that's the heart of their argument. So how would you address that?
I would say
what they're saying is the circumstances speak for themselves and are the proof that, you know, that either there is a defect with the device or that the device wasn't properly handled.
Yeah, and Your Honor, that may be a valid argument in a non-political subdivision setting. You have the burden is on the plaintiff in 2744 cases, Revised Code 2744. The burden is on the plaintiff to show a specific exception to immunity. And under this exception, there are three prongs, and they're not just employee negligence, not just a res ipsa argument, which I don't even know if plaintiffs necessarily made that argument at the trial level, but you have to show the grounds and you have to show the physical defect. So the burden is on the plaintiffs to show those things and put evidence of those supporting those exceptions, elements of the exception in the record. And that was not done here, Your Honor. So the trial court correctly found that there is a valid immunity defense. And I'd be happy to touch on the argument of reinstating immunity if the court wants to hear it. We think obviously that even if the court were to find immunity or find that there was an exception to immunity, that there would be a valid reinstatement of the immunity due to the fact that this involved the reinstatement under 2744-03A5, which is how the political subdivision decided to use equipment. There's no evidence of reckless or wanton conduct. There's nothing in the record to suggest that the employee acted in a reckless manner, and there's nothing to suggest that the mower wasn't maintained properly. So that's clear evidence of proper action.
And can you elaborate a little bit more on that? Because it's, you know, exercise of discretion, of judgment or discretion in determining. And you're saying you're focusing in on the how to use equipment.
How to use equipment, yeah. And I think the one Ohio Supreme Court case that's instructive is the Elston versus Howland Local School District, which involved a baseball team's practice. And I think an individual was hit by a batted ball, and the coach in that practice had used a pitching net and had set it up in a certain area, and the area where he had set it up didn't prevent this accident from occurring. And the Supreme Court said, well, you know, this is discretion with respect to how to use equipment. In that case, the netting. And so he was, because there was no reckless conduct, bad faith, wanton conduct, he was found, the school district was found to be immune. I think that's akin to what you have here. You don't have any reckless or wanton misconduct. And
I'm trying to understand the how to use equipment.
Yeah.
Because it seems like depending on how that is viewed, that it can become all encompassing whenever there's any equipment involved. because you're using the equipment. So that's what I'm trying to understand, whether, whether the legislature intended that once there was equipment, that this, this third prong is going to kick in and bring it back into sovereign immunity,
Yeah.
or whether the how to use is really intended to be more narrow than that.
Yeah, and I think you just have to look at the plain language of the statute, and the plain language says how to use equipment or materials or personnel. I mean, those are the things that the
So
current.
where is the discretion here on how to use the equipment is what I'm trying to understand.
Well, I think if plaintiff is arguing that, he shouldn't have parked it where he parked it, I think that it's discretionary as to how he turned off the mower and parked it in a particular location. I mean, our argument does not necessarily focus on this reinstatement. I think that first and foremost, we believe there's no exception to immunity here. I'm just elaborating on what our position is.
No, I understand that, and I'm in the event we get there,
Sure. Sure.
I want to get as much of your perspective as possible.
Sure, I appreciate that. And our perspective is that it has to do with the plain language of the statute, which just talks about how to use a piece of equipment, similar to the Elston versus Howland case, in which the school district and the coach there, where he decided to set up that netting, is what the court said that was discretionary, how he used it. Unfortunately, it didn't prevent the injury in that case. And here, how they decided to ultimately set up the mower and where it resulted in an accident. And unfortunately, that's a discretionary decision with respect to use of the equipment. And therefore, without recklessness or wantonness or misconduct, we think immunity is reinstated.
All right, thank you, Mr. If there's no further questions, thank you, counsel. Mr. Mahoney, you still have your rebuttal time, sir.
Thank you. Let me address the last issue first for you. I believe the statute is pretty clear that I think for you to have an exception with the equipment, you have to use the equipment as it's intended. It's used to cut grass. It's not used to run golfers off of the golf course, or to be recklessly operating it down a hill where there's other persons standing nearby. That's why the mower stopped at the top of the hill to let these gentlemen tee off, wait until they had cleared the area before he continued on with his cutting duties. Let me address the issue of the operator of this vehicle. I don't think there's any disagreement that it's a motor vehicle. I'm sorry. I think that's in the pleading itself. However, the fact of the matter is this gentleman was not available at the time to take his deposition. I think Mr. Irie would agree and would tell you that his mental capacity was no longer available for him to be able to do so. The only person we had available to do was the risk manager. We took Mr. Bruce's deposition and he referred to the report. The mower being inspected was not going to be any effective at all to it, because it was damaged in the actual by their own report, and they could not determine the source of what the defect was after it had already been damaged, as to whether or not it was the brakes or something, or operator error.
So
However,
the damage to the mower is not really at issue, that there is damage.
There was damage to the mower, and
Right.
That's their own report. So the issue is nowhere in the statute does it say that res ipsa and the inference cannot be drawn. Those are issues of fact for the jury to determine, really not for the court, even though it's under immunity. Our argument would be that it's self-fulfilling prophecy for the appellee to argue in this case that we can't prove that the mower was defective because it was damaged. We also can't prove that the operator did something wrong because he was no longer competent to testify. However, mowers don't just start running down the hill and hitting people.
Mr. Mahoney, let me ask you a question.
Sure.
In airplane crashes, tiny bits and pieces of the airplane, and somehow people are able to put it back together and figure out what what, if anything, was defective. And I guess my question goes to, just because the lawnmower was damaged doesn't mean that somebody could inspect it and determine whether or not the brakes were working properly. I'm assuming if it went down a hill and hit your client and then hit a tree or went into the woods, that the mower deck may be damaged, but I don't know how that would affect somebody taking a look at perhaps trying to figure out whether the brakes were functioning properly. And, you know, I don't know whether they were able to start the mower back up and drive it away, whether it be towed away, et cetera, et cetera. So my question is that, you know, it seems to me that someone should have inspected that mower and determined whether or not the brakes were working or not.
Well, Your Honor, you're right. And I guess if this would have been the day after and I would have had access to a mower and I could have got somebody there, that would have been a good argument for us to say. At the time that we became aware of this, that mower had already been gone. It had been already been inspected by them, dismantled, damaged beyond, they had already conducted their report. We had no way to do an independent, at that point, inspection or a report. So you're right.
Well, that's a function, I guess, of when your client decided to call.
It's partially a function of when the client, and it's also a function of just being able to get access to something. However,
And is that part of the record that it already had been dismantled at that, or when it had been dismantled?
no, we were only told, and I think somewhere in the discovery, and I apologize, but that there had already been the report, and that they had meant it was inconclusive from their standpoint as to what it was. They had the maintenance records, which they provided, which showed that the thing had been routinely maintained. So our argument was at that point, and still would be, that mowers don't just start rolling down a hill for no reason whatsoever. And the mower, as you've already heard, was off. If it was off, then it would have been engaged in park or something else, that it would have had to have something done to the mower to cause it to go out of gear and just roll freely down the hill. This is a riding mower. The pictures are part of the record. They were part of the depositions. It is a riding mower. It is a large mower. It has a mower deck. As it rolled down the hill, it actually hit Mr. O'Brien and knocked him onto the deck, taking him all the way down to the hill, the bottom of the hill where it came to rest, where he went off of the mower deck. So there was no testimony in the record from Mr. O'Brien that anybody said, get out of the way, or warned him. He was actually just put away his club and was over by the cart when he got struck. So our position has to be that mowers don't just start rolling down the hill for no reason whatsoever. And either
Attorney Mahoney,
Yes.
is there any, I just want to clarify, I just want to make sure, is there any issue of fact with regard to whether the lawnmower was parked and number one, and whether the lawnmower was turned off at the top of the hill?
there's no dispute of fact on that. That has been I believe Mr. O'Brien's the one that testified that the mower, they heard it, the guy turned it off, and he was at the top of the hill. I believe that was in the record of the testimony. I'm sorry, I don't have the page in front of me, but I believe that was in the record that Mr. O'Brien did testify to that fact.
And was the operator still mounted onto the mower when it took off? Or had he stepped off?
No, he was on the mower the entire time. There's no evidence that he was not ever all on the mower the entire way down the hill and called for the help. I'm trying to remember if there was, the one comment I wanted to make is that, you know, obviously, I'll go back to that last issue, the issue they kept talking about, the physical defect and on the premises, in that Mr. O'Brien was struck by the mower and the chute part of it that comes up. The only case we were able to locate is, I believe we cited it, there's one lawnmower case that talked about a chute being defective. That's not relevant to here, except that it does show that a motorized lawnmower can have a defect to it to fulfill the statute. That's the only reason I point that out.
Thank you, Mr. Mahoney. You are at your time. Thank you for your arguments this morning. The case is now submitted.
All right.
Thank you.
Thank you all.
Thank you, Your Honors.
All right, and then the last matter on the docket this morning is C19-0680 and 721 in Re AF. Again, good morning, Ms. Kars-Nestler, Mr. Havlin. Ms. Nestler, did you wish to reserve some time in rebuttal this morning?
Yes, Your Honor. 5 minutes, please.
All right, I will keep your time again when you're ready.
Thank you. May it please the court, counsel, my name is Julie Kars-Nestler and I represent the appellant AF in this matter. The issue in this case is a delinquent independent's right to counsel, who that right extends to and who may waive that right. Because the juvenile court has interfered and denied AF access to counsel and the agent of that counsel, AF respectfully requests this court to reverse the juvenile court's decision. Further, AF's conduct in stepping backward onto the foot of an officer is insufficient to establish the offense of assault on a peace officer or is otherwise against the manifest weight of the evidence, and she is similarly asking this court to reverse her adjudication. I'd like to start first this morning with the first assignment of error and the right to counsel. It is undeniable that a parent cannot waive a child's right to counsel. The right to counsel belongs to the child and their parent, whether it's a biological parent or the custodian by way of the Department of Jobs and Family Services, cannot waive that right. Further,
This was a social worker. My reading of the briefs is this the complaint you're talking about? It wasn't actually the attorney. It was someone that was going. It was a social worker or someone else on behalf of the attorney that was going to speak with AF. Is that correct?
that's correct, Your Honor. It is.
How does that kick in a right to counsel at that point?
Your Honor, the right to counsel includes their agents. I think that's well established in the case law that attorneys often employ non-attorney individuals to assist in their counsels. For example, psychological experts are routinely utilized, mitigation specialists are routinely utilized by attorneys to collect information to represent the client, and that can be in a number of contexts. It can be prior to trial, post-trial for sentencing purposes, and even post-conviction. So
anybody that the attorney wants to go see their clients, if they're, let's just say that they're incarcerated somewhere. So it's your position that if an attorney wants anyone to go see them on their behalf, they become an agent and then they should have access to those people.
if it's an agent of the attorney and they're going at the direction of that attorney, then yes. And in this case, this is a little bit of a specialized, I don't think it matters who the agent is. In this case, it did indeed involve a social worker. So they obviously, they occupy a little bit different space. They have a little bit different professional expertise than the attorney does. The attorney is there to represent the legal issues of the case. And sometimes they're going to need to employ other individuals with another area of expertise to represent the client. And in this case, the attorney, the counsel, found that it was imperative to properly represent this child in her delinquency and dependency cases to have a social worker, because I think it's quite clear in this case that placement or where AF was going to reside was the issue before the court. She had been to a number of placements and was not successful. So it was counsel's position that she needed that other person, that other individual with a different area of expertise than herself to help fully represent AF in this matter.
Ms. Nestler, let me ask you, the social worker's function was more dispositional rather than useful at trial. Is that correct or not?
Well, Your Honor, I think that is an accurate assessment, but I do think it's important to note that the time in which the juvenile court denied AF access to counsel, she was in both a dispositional phase and a pre-adjudication phase. Specifically, she was awaiting disposition on a probation violation in the juvenile, the 18 case number, but she was also awaiting trial on the assault on a peace officer cases.
Okay.
So she was, obviously the social worker was kind of working the aspect of the dispositional aspect of AF's case, but she was pending both adjudication and disposition. And I believe the record is quite clear that JFS was going to deny AF counsel access to counsel, like legal counsel, as well as social worker when she was in placement. I know the state has made quite a bit of deal about the fact that once AF was had a probation violation and was removed from that placement and placed into the youth detention center, legal counsel and social worker were able to obtain access to AF. And the reason for that is because the administrative code specifically requires detention centers to allow clients to have access to legal counsel and their authorized representatives. And I provided that administrative code in our reply brief. So for that reason, it is quite clear that the right to counsel does include any agents that the attorney has decided to employ. If this court were to say that agents were not part of the right to counsel and that a parent or custodian were able to limit who the legal counsel may employ, that would severely limit and restrict the right to counsel. The right to counsel is the source of that right is both constitutional under the Due Process Clause, as well as statutorily under 2151.352. That statute provides delinquent children as well as dependent children the right to counsel at all stages of the proceedings. That's quite important for this court to remember and consider, is that this is a broad right, and that AF's specific circumstances and the fact that she was both before the delinquency arm of the court and the dependency arm of the court is that her interaction with the juvenile court is ongoing. Even though she is in placement right now, she continues to have reviews with her dependency magistrate. And as laid out in our brief, as well as our reply brief, the disposition is also ongoing. She's on probation. She will remain on probation until the juvenile court terminates that order or until she turns 21. So again, these are ongoing proceedings. These are proceedings which, even though she has been transported to placement, they're ongoing, and she is entitled statutorily to that right to counsel. And
Ms. Nessler, let me ask you, Ms. Nessler, did the court hear from the social worker prior to disposition on the, just say the case that was adjudicated, as well as you indicated there was a probation violation, which we're aware of. So the question essentially is, did the court listen to the social worker prior to making its decision as to disposition of this child?
So sure, Your Honor. Just to clarify a couple points for the record, there were several dispositions while this was pending for AF. She went to one placement was that Pomegranate. She came back to the detention center. She went to Abraxas, did not complete that program, was there for a very short time, came back to the detention center, and then was sent to where she currently resides today. But to your question, Your Honor, the social worker did provide a report in disposition to the court. But again, the reason that she was able to do that is because AF resided in the detention center, and statutorily under the administrative code, they had to provide the social worker that access to her. Moreover, as cited in our appellant brief, is the fact that the right to counsel, if there is a state intentional interference by the state, or in this case, by the state and ratified by the court, the appellant does not have to show prejudice for that violation of their right. And although that body of case law arises out of the Sixth Amendment right to counsel, AF would submit to this court that it applies with equal force. Simply because AF was able and the social worker was able to provide a court or a report in disposition does not remedy the fact that she was indeed and is still indeed being denied access to counsel and to counsel's agent, specifically the social worker in this case. And I think, Your Honor, I don't know if this was also a part of your question, but before the magistrate ruled on legal counsel's motion for access, they did receive into evidence an affidavit from the social worker outlining kind of what her relationship was and what she was doing on behalf of the attorney and on behalf of the client in this case. Specifically, one of the reasons why the juvenile court found that they could deny her access is because the social worker was investigating alternative dispositions. And the court found that that was the providence of JFS and not an agent of the legal counsel. However, again, this is the child's right. The child has the right to counsel, and the sole purpose of that counsel is to present for the court the expressed interest of the juvenile, of the child. While it'd be certainly under the prerogative of the juvenile court to either not find that it has the most weight or it's not in the best interest of the child, that's for the juvenile court to decide. But to deny access to the client and to counsel of who they would like to employ to work on behalf of the child and to express those interests to the court, that is just completely contrary to the constitutional right, the counsel, and the statutory right. Again, the statutory right is quite broad. It's all stages of the proceedings. So it is our position that this right was violated. AF does not have to show prejudice to establish that violation, and we've asked that this court reverse the reverse the juvenile court's decision in order that AF be able to have access to that legal counsel as well as counsel's agents while she's in placement.
Counsel, you have reached your time if you want to save any rebuttal time.
Sure. If I could just briefly touch, I'll go into my rebuttal time to briefly touch on the sufficiency and manifest weight and reserve the rest of my time for rebuttal. Just briefly, it is our position that AF's adjudication must be reversed. As to sufficiency, it was clear that the question was, did the state prove that AF acted knowingly? In this context, it was she aware that her conduct would probably cause physical harm to Officer Simmons? The case law is quite clear that physical contact alone, a shove, a push, a grab, those are all insufficient to establish an assault. Rather, it has to have the requisite mental state. And it's a subjective test that's based on objective criteria. Here, those factors were that the difference in shoes, AF was wearing flip-flops, the officer was wearing military-style boots, the inability of AF to move. At the point of the contact, there were other officers that were standing around AF. She was handcuffed. The officer was holding the handcuffs. There was there's an inability for AF to move at that time. And again, this is a child. This court must consider that fact in judging her conduct. We would submit that a reasonable person would just not be aware under these circumstances that a step backwards with flip-flops on the foot of someone in such as boots as the police officer would not cause any sort of physical harm. So for that reason, we'd ask this court reverse on sufficiency. And then just briefly as to the manifest weight, it is AF's position that the magistrate is the one who made the appropriate call here, and the more credible evidence supports her finding in this case. Specifically, the court had at trial evidence of AF's specific intent, and the magistrate in ruling on this case found that AF's subjective intent, which was to just move this officer backwards, that she found that was the most compelling and the most credible, and therefore dismissed the case. The judge, without taking any additional evidence, reversed that decision.
The trial judge referred to exhibit, the trial magistrate only referred to State's Exhibit A in their decision, whereas the trial judge referred to State's Exhibit B, which clearly shows that AF intentionally stomped on the officer's foot?
Your Honor, I believe that the magistrate did view all evidence, and I don't think there's any question that she intentionally stepped backwards onto onto the officer's foot. I don't think there's any question that whether or not this was accidental. It was intentional. The question was the purpose to move her backwards, or was the purpose to cause physical harm? And the magistrate found that based on the fact that the officer is the one who instigated the physical contact, she's the one who yanked on AF's underwear and snapped them, that immediately AF said, "Can you stop? You're making me uncomfortable." And there was kind of some protesting between the two, and that it was that initial conduct of Officer Simmons that the magistrate found was most compelling when viewing the officer's testimony live. She found that AF was credible and the officer was not credible, and therefore dismissed the case. So we would submit that certainly the magistrate considered all the evidence. The video was played during trial that the magistrate certainly would have viewed. So we would contend that she certainly completed an accurate assessment of the facts of this case. If there's no additional.
And I just want to clarify, the video was obviously introduced into evidence. Was it played before the magistrate?
Yes, Your Honor, it was. Okay. But both exhibits were.
All right, thank you, counsel. Mr. Havlin.
Excuse me. Good morning, Your Honors. Counsel, may it please the court. Alex Havlin on behalf of the state. I'll start with the first assignment of error as well. It's my position that.
Counsel, can you turn your volume up a little bit? We're having a hard time hearing.
Sure.
Thank you.
Sure. Is that better?
No.
It was better when you began. Something happened.
Yeah.
Is it working now?
It's just.
We can hear you just barely.
Sorry, this happened last time and I thought our tech people had fixed it.
We can hear you now.
Okay, I'll
Getting
just stay
better.
right here. Sorry, I'm so close to the camera. It's my position. I guess essentially the best way to phrase it is I'm unsure what relief exactly can be granted here based upon the state of the record. So at some point when the defendant was placed at Pomegranate, apparently the social worker was not granted access. I believe the record is clear that after that point.
And Attorney Havlin, the social worker at some point was granted access. Is that right?
I believe at every instance, but for that one at Pomegranate, I believe the social worker has been granted access.
And because what I understood was the social worker had some sort of access, and there was a discussion that took place that was found to be troubling and became the basis for the determination to discontinue access. And notice the words I'm using, I think it was to discontinue, but maybe I'm wrong on that. And that's what I want to make sure that I'm not misunderstanding that.
I believe my understanding of the record, I'm not eminently clear on what happened on the dependency side of this is a little fuzzy. Even after, if there was some determination made to no longer grant access, she was given access the rest of the record in this case. The entire time the juvenile was at 2020, the social worker was allowed to go. There was never a subsequent objection to any lack of access. The juvenile court judge puts in her entry, I want it to be known that she's been given access the entire time she's been at the juvenile center. So I don't think it's accurate that she was prevented from seeing this defendant at any point other than at Pomegranate. So whatever the entry says, I don't, as the juvenile court judge made clear. So the decision seems to almost be contrary to what actually happened factually. I think a lot of this too, we're sort of conflating maybe some issues, whereas what exactly does access mean? I think when you look at the conclusion of this case, as Judge Winkler, you brought up, the social worker was able to provide a report, and at the ultimate disposition hearing, there's no argument that, you know, I was drastically prevented from performing what I wanted to do, that otherwise I would have done X, Y, and Z had I been given access. And so I don't think she was prevented in any fashion really from doing what she was purportedly there to do.
So if we were talking about just counsel, only counsel, right?
Sure.
Would that be the same rule of law that you would apply? So if there was some access that counsel was limited to, would counsel have to establish that that limitation had in some way undermined their ability to represent? Or was it just merely the lack of access is sufficient?
No, I think if this, and that's why I make a point in the brief to say this, I don't believe that this record at any point demonstrates that an attorney, Ms. Chang, I believe was the attorney, was ever not.
No, but you just shared with us sort of a way for us to look at it, and I'm asking you if we were talking about counsel, whether that would apply.
No, I think if counsel wasn't allowed to go, that's a problem. If counsel's not given reasonable access, I think that's.
So then are you saying that if counsel has someone in their team, and I'm just going to call it team, okay, and that person at some point in time is limited access, then the rule of law would be different than if it was counsel?
I think it is. Yes. I don't think it's, this goes, Judge Mock asked the question before, where does this stop, I suppose? And I think there's a lot of things that come into play when we're talking about non-attorney access, you know, availability of various places. I think the administrative code point it's unfortunate that the administrative code section wasn't brought up before this, because I think we could have had a more developed record on what exactly it means. But I think that's a good one. The administrative code says detention centers must have rules to address these situations. And I think likely, I don't know, and obviously I didn't have a chance to reply formally to this, I assume that 2020 and both, for instance, DYS have rules on the books that address how this is supposed to work. It's the administrative code, however, so it's guidance. And I think if this is a problem where Pomegranate somehow was in violation of the administrative code, I don't know that Pomegranate is detention. It's not in this record, certainly. I'm vaguely familiar with it. Then that should be addressed in some fashion administratively. I don't.
Mr. Pavlin, let me ask this question. If AF is no longer at Pomegranate, for instance, and or the disposition's already taken place, why are we even having this discussion now? How is this not moot? What possible relief could we grant her at this point that would be meaningful?
That's precisely my point. And I think we're in the same position we were in with AB. It was a similar, this was an agreed to disposition that's not being challenged presently. And the record, I think, demonstrates that the problem that original motion seeks to remedy has not occurred again. So I don't know what a decision from this court saying that's overruled, but you're just still going to stay exactly where you are, nothing is going to change. I think that is advisory completely. I think it's an advisory opinion. I think, you know, the one exception that could be brought is the capable of repetition. I think anything AB in the previous case was still on probation, also still subject to any of these other, you know, potential relitigation of some of these issues, and that wasn't found to suffice either. So I don't believe there's any relief that this court can grant via this appeal. I think it's something that, again, if it would come up in the future, perhaps, but it seemed to have rectified itself during the course of this case below. In terms of, I guess if there are no more questions on the first assignment of error, I'll go to the second and third. This is a question I think, obviously this isn't an attack with a weapon on a police officer or something like that. But the way the law is written, when we're looking at assault, it doesn't, it can be attempt to cause physical harm. The amount of physical harm, as I cite in my brief, doesn't even need, the Daniels case says the slightest injury is sufficient proof to prove physical harm. You don't even need that because the attempt to cause physical harm is present. So in this case, what's in the record that tends to show an attempt? The defendant admits that I stepped on her foot to get her to back up. I think this begs the question, as I wrote in the brief, why would she back up? If it weren't, you think it may hurt her and cause her to move. I think that's certainly, based on the videos and the testimony, that's a fair conclusion to be made on the totality of the evidence.
And that's her exact testimony, is that correct?
I believe so, yes. Not testimony. It's in the video. She's in the back of a cruiser.
No, let me clarify. You said that she had said, I stepped on his foot, or in order for, is it him or her?
Her.
In order for her to back up.
Yes, it wasn't testimony, it was video footage. She was in the back of the police cruiser at that point.
Oh, I understand. And then she said, because I guess
one of the
somebody
officers-
asked her why, and then she
Yeah,
said,
yes.
okay, so is that footage part of the record then?
It is.
It is, okay.
It is, yes. And so I think with that admission, and certainly when we're going to looking at the mens rea of knowingly, I think that tends to show a lot. And going to the magistrate's decision in this case, somewhat confusing. I think I'm not certain what, if anything, saying Officer Simmons' credibility changes. Officer Simmons, her testimony really was, she stepped on my foot and I told my boss and that's all. The video in this case is really what I think the juvenile court judge watched and came to that independent conclusion.
And that second video, I'm sorry, Attorney Haviland, just to clarify, that second video that you're talking about in the cruiser, was that also played before the magistrate?
I believe so. I believe it was played. She was of the statement, I'm sorry, or of the
Yes,
incident.
that's correct.
I believe it was also played. If not, she was aware of the statement being made. Certainly, but I believe it was also played.
Was there testimony with regard to that statement?
I thought that one of the, and I can't recall the officer's name, I believe one of them said it.
Okay. I mean, we can check the record. I just wanted to, and there was no motion to suppress filed, is that correct?
No, there was none litigated. No, that's correct.
Thank you.
And I think, just going to conclude briefly on this issue, the AS case is where this court said that the juvenile court judge is the ultimate trier of fact, completes an independent review of the issues. I think Judge Bergeron's dissent in AS also is applicable to this case because he talks about, even absent new evidence, if the juvenile court is reviewing, he says, testimony with documentary evidence, I think. But in this case, the video would serve as that. I think that even applies in this case where.
Yeah, I think the point of that dissent is, you've got this rule that allows for de novo review. And so if you have issues that turn on credibility, that the only entity that had the ability to make those determinations of credibility would have been the magistrate. And so what makes the conversation interesting is that when it comes before us on review, there's this great amount of deference that we give to that credibility. And we're giving it to the trial judge, even though the trial judge was not the one that determined credibility, it was the magistrate.
Correct.
So I don't know if, but that's really the heart of what that's all about.
Sure. And I
So
think,
in this case, that's what it comes down to, is like, look, if it was something that was, the credibility was a determining factor, or the determining factor, then it becomes troubling. But if there's evidence that speaks for itself,
sure.
and that's equally reviewed before the magistrate to the trial judge.
Sure. And I think in this case, also, I think the video speaks for itself. The statement of the defendant speaks for itself. The credibility determination, as I kind of hinted at before, I'm not certain what it even functions to do in this case, because Officer Simmons' testimony wasn't really, it was nothing that we didn't see on the videos. So I don't, even if we were to say she was wholly incredible, the videos show what they show, and the statement is what it is. So I don't know. I would submit that this isn't a case where a credibility determination rules the day, more so than many cases. If there are no additional questions, I'd simply ask that this court, in terms of the first assignment of error, find that it would be an advisory opinion. In terms of the second and third, affirm the decision of the juvenile court.
Thank you, counsel. Ms. Carson-Hessler, you have about 2 minutes.
Thank you, Your Honor. Just briefly as to the last point from the state, I would point this court to page 109 and 110 of the trial decision by the magistrate. She references having to assess the credibility of the witnesses. She says that it was difficult to assess because there's so much going on. Well, I think Officer Simmons is, quote, a fine officer. I think she escalated the situation when she came on the scene. And looking at the video, I found it compelling that when the officer arrived on the scene, her physical action towards the youth exacerbated the situation, provoked the situation, and was not as she testified. So that's page 109 through 111 of the transcript. I do think that a credibility was a part of the magistrate's assessment in this case. And again, she found most compelling AF's testimony of her subjective intent after viewing all of the exhibits in this case, as well as the testimony of the officers. So we would ask that this court reverse her adjudication on the assault on a peace officer. As to the state's contention that the issue with regards to the first assignment is moot, it's absolutely not. This court can certainly provide adequate relief to AF in the form of granting her access to the social worker and her legal counsel while she's in placement. Again, the motion, while it specifically addressed the placement of Pomegranate, the motion made clear, as well as the hearing before the magistrate and in the objection hearing, was this encompassed all placements across the board. JFS made note that they would be limiting AF's access to this social worker and this counsel while she was in placement, regardless of where that placement is, and that's still happening today. So this court can certainly offer relief to AF. This case is wholly different than AB because she does occupy that dependent status. So that is an important and crucial distinguishing factor in this case. And again, focusing on the fact that the social worker was able to ultimately present a report in this case, it focuses on the wrong fact, to be honest, Your Honors. Instead, again, that is saying that the appellant has to prove prejudice, and the case law does not. This case law says the defendant does not have to show prejudice. All they have to show is a denial to counsel. I think the state specifically conceded today that if it was legal counsel that was denied access in this case, then that would be a problem.
Ms. Messer, you have reached your time limit. So thank you very much for your arguments this morning. The cases are now submitted. Thank you. Thank you.